of the human sexual.
Mr. Bedram, I'm reluctant to take the shine off you. But these submissions have been well laid out this morning. And I think that you made a very valid point. That because earlier on there had been the inquiry as to what the fiscal impact analysis should contain. And you have drawn the attention of the court to section 12. I think that regulation 12, I'm sorry. But so that responds to the question.
Very well. Lady,
you are not done.
No, I'm rounding off. I'm rounding off. Kindly.
Yes.
Lady, all said and done. The first defendant at paragraph 20 of his affidavit in opposition refers to the letter from the Attorney General or the report from the Attorney General to the Constitutional, Legal and Parliamentary Affairs Committee of Parliament.
We are waiting for you.
In which the Attorney General expressed his reservations about the bill. Milady, the Attorney General, in his submission this morning, has clearly indicated that those concerns raised by him were not corrected or factored in the bill before attempts to transmit.
I believe that at this moment, the issue is whether Parliament should be injuncted.
Exactly.
You sued Parliament. Yes. Dr. Amanda Odoi sued the Speaker. So whether Parliament should be injuncted from transmitting.
Exactly.
Yes, this bill.
My lords, with respect, we see the Speaker as the embodiment of Parliament.
Yes.
So when we talk about Parliament,
yes.
We are
why should we restrain the transmission? In the earlier submissions, the Council for Parliament, who is still the Council for Parliament in the present case, clarified that the President has 3 courses of action. And so if the President agrees with your submissions, with whatever is being said in this court, his lawyer or advisor is the Attorney General who is in court. The Attorney General could advise him to send it back to Parliament for whatever is deficient.
Lady, I state with reservation that...
So this court should not interfere?
Lady, I state with reservation that so far as we are concerned, an advice always remains an opinion. The final decision lies
GVA versus Attorney General.
Exactly. So, lady, it may be taken or not taken. And this is the more reason why we safeguard ourselves under the Constitution by seeking an injunction. Lady,
Counsel.
Yes,
in the transmission process, does anybody exercise a discretion which you can stop?
Lady, the right to come to court is an inherent one in every citizen of the land. And lady, our concern is that going by Article 18A11, Roman number 2, which has already been alluded to before this court, lady, there was a fundamental breach of the Constitution in the Speaker's admission of the bill in the first place to deal with. And on that score, on the strength of Article 2:1, any citizen of the land will be at liberty to seek redress before your lordship.
And you are done.
This is the more reason why we believe this is a proper ground for this application to lie. I rest my case.
Thank you, sir.
Lady, we agree in totality with the submission made by the Attorney General. That is the
The Attorney General says he doesn't want to be linked
No,
to
I agree.
anybody.
I agree with every submission he's made. In fact, he's rather complimented our submission. So we have no cause to object to anything he has stated.
Attorney General.
Let me rely on our statement.
I believe that you rely on your submissions in the current case will be totally in tandem with what you have already said.
Yes, indeed, that's so. I mean, and I don't want to bore the court with a repetition of those arguments. So to develop just one point, the facts about the prohibition that I stated is implied in Article 108, the prohibition of Parliament from proceeding with a bill. I argued fully on that, but I'll develop the argument further by stating that that prohibition on Parliament from proceeding, unless certain factors have been met, actually implies a condition precedent to Parliament's power to act upon such a bill at all. I will state further that indeed that prohibition actually then operates as a fetter on Parliament's power from proceeding, because it's a condition precedent. Without the satisfaction of that condition precedent, every step taken by Parliament is null, void, and of no effect. And respectfully, if that is the case, the question arises whether indeed
there's even a bill.
There's a bill at all. Or there can even be a cure, a remedy for the default of the Speaker of Parliament in proceeding. Early on, my lady would observe that I actually made a point in answer to a question from the court that I would be hesitant in stating that the Speaker did not make such a determination. And I would rather say that there was lack of evidence of such a determination. Clearly now I've seen evidence of the omission. So I would amend my earlier submission to say that the Speaker actually omitted, because there has been such clear concession by the first defendant in his statement of case, where he stated that the Speaker did not present such a determination at all. Already, I would state that, so clearly, there was nothing, no basis on which Parliament could proceed, because there was a failure to satisfy the very important condition precedent of the Speaker or the person presiding, presenting an analysis of the impact on the consolidated fund. And simply, I would further submit that such an omission cannot be cured by the President's election to refer the bill back to Parliament for reconsideration. Indeed, what if the President does not refer the bill back to Parliament? It means the nation lives with their own constitutionality. That would clearly be the implication. If the President decides not to present the bill back to Parliament, the nation will live with such unconstitutionality. And that will be a huge scar on the constitutional landscape of the nation. Especially, I submit that there's again no independent power of Parliament to reconsider a bill after the processes in Article 106 of the Constitution have been satisfied, which indeed have been up to this stage. Parliament has fully exhausted all the processes of considering a bill. The bill has been introduced in Parliament, has been read for the first time as required under Article 106, Clause 4 of the Constitution. It has been referred to the appropriate committee of Parliament under the same Article 104, Clause 4 of the Constitution. There has been a deliberation. There has been a deliberation upon the bill by the appropriate committee as required by Article 106, Clause 5. Indeed, the bill has been read for the second time. It's been subjected to full debate as required by Article 106, Clause 6. And indeed, it has been read for the third time has been passed by Parliament. Especially, my submission is that upon the satisfaction of all these steps required under Article 106, there is no room for Parliament on its own to reconsider such a bill. And therefore, there is no provision for a remedy or a cure of a failure to comply with Article 108, paragraph A of the Constitution.
Honorable Attorney General.
Yes, especially.
Did I hear you say that after a bill has been assented to and it's become an act, that there's no other opportunity?
Or provide a remedy or cure, as earlier on advocated by my learned friend. Does not exist.
No. What your learned friend is saying, I think it's compatible with what you're saying.
In the public
I think you accept that this is unfair. But as to whether you knew it or not, you said it's new information to you.
Absolutely.
This case has been on the table. Does that mean that your researchers lacked, or Parliament's researchers lacked that much diligence?
My lady, I just got that information. I don't need to.
Does that mean that Parliament's researchers lacked that much diligence?
My lady, that is the view of the court.
This case has been pending since last year.
He's worked for a public institution. My lady knows, the Attorney General knows, a number of times we've granted them extension of time. And the unfairness will be cured by the fact that he will be served with a copy.
No, kindly round up.
Yes,
I don't know if I will give you leave to bring it. You may file it for the substantive action, but not for this application.
Very well, my lady. But I'll draw the court's attention to it anyway. But on the strength of even the submissions that I made, we take the view that this cannot be a ground for injuncting a process that still has several options, constitutional options available.
Thank you. So this application is also adjourned to the 17th of July. July. For ruling. Yes, sir.
Is it going to be a composite ruling, one ruling on both?
Oh no, we are unable to do that. We will give a separate rule. Of course, the second one can adopt the first one. We'll refer to our ruling in the first case.
I thought that it should have been appropriate since the same facts and all.
No, we have not consolidated the cases.
Okay, yes, okay, but a ruling which.
If you like, we can repeat it. Right. So the ruling is adjourned to 17 July 2024. Thank you. We must thank everyone for their patience, but this is a lot, right? This court has to, there are several cases pending, right? That's why we need more Supreme Court judges. The discussion must be placed in context.
It would actually have been very wonderful to see 3 chambers of the Supreme Court sitting at the same time. One in the old Supreme Court upstairs, and then perhaps
you should build a new Supreme Court building for the nation.
Right.
Or the Minister of Finance should.
The panel will be reconstituted. All rise.
Everybody should get some lunch. We'll be back at
and 2 cases have been heard by the Supreme Court. The first was a researcher at the University of Cape Coast, Dr. Amanda Odoi, and he filed a suit at the Apex Court for the Supreme Court to injunct Parliament from transmitting the anti-gay bill to the President. The second one we also heard was from journalist and lawyer Richard Delaskai, also seeking a similar relief. But interestingly, the Supreme Court did not consolidate these 2 cases. In times past, when cases are of some similar nature, the Supreme Court will consolidate and then give it or hear them together and then thereafter give the ruling together. But this is different. In fact, when the hearing for today ended, the CJ indicated that this is not going to be a composite hearing and they will give their rulings differently. Now let's start with Dr. Amanda Odoi's case, where the lawyer for Dr. Amanda Odoi, Ernest Yao Akon, filed an injunction application just preventing Parliament from transmitting the bill to the President. His argument is simple, that should the courts decide not to grant the application that they have filed at the court, it will lead to some irreparable damage, because when people heard that the bill has been passed, people construe that it is the law that has been passed, and so there were mayhem, other people were injured, some violations and human rights breaches were also occasioned. But that is why they are in court, for the court to injunct the process so that the right things ought to be done. All the remedies that have been sought would be tackled. In fact, the learned Attorney General came in and supported the position of the lawyer for Amanda Odoi. He indicated that, in fact, this current bill was a private member's bill, and to that extent, it is a charge on the consolidated fund. It is going to be a drain on the public purse, and so should we allow this to stand, it means that it's going to really have an incalculable damage or some consequences on the public funds. Lawyers for Amanda Odoi indicated that under Article 108 of the 1992 Constitution, any bill that emanates from a private member that seeks to be a charge on the consolidated fund should not be attached, and so rather such a bill should come from the President. And so their point really is that once that Parliament did not do its research well to know that this bill is actually going to be a charge on the finances of the country, then that bill should not have even been entertained in the first place. And this was also supported by the Attorney General, who says that, well, indeed, they support this move because a bill, and he referred us to 2017 when a similar private members bill was passed under Speaker of Parliament Michael Quay, where that bill was admitted. In fact, there were a lot of discussions and debate about it, but the difference that the Attorney General cited was that that bill that came from a private member was not a drain on the public purse, and that is materially and substantially different from the current action that has been taken. And to that extent, any action that has been done by Parliament should be declared null and void. In fact, they have not gone into the substantive matter. This is an interlocutory application that has been filed by lawyer Richard Delaskai and researcher Amanda Odoi. And so once they said that, the Attorney General indicated that because the condition precedent was not met, was not satisfied, in fact, Parliament had no recourse, had no cause of action, had no power to entertain that bill. And the lawyer for the Speaker and, for that matter, Parliament, Tadesori, came in and said, well, even if there is something fundamentally wrong with the bill, the fact that it is a charge on the consolidated fund and that affronts Article 108, they should allow the process to continue, the transmission of the bill to continue to the president. He says that, well, once it goes to the president has various actions to take. That bill could be resent to Parliament upon the president's observation and suggestions, so that Parliament will have a relook at that. That was also subject to some debate, because the Attorney General said once that is done, Parliament is foreclosed. Parliament cannot reconsider the bill because they have failed to do due diligence before entertaining that bill in the House of Parliament. And this raged on for some time. So intermittently, the judges of the Superior Court would come in and they posed some poignant questions. One of them was to the applicant, who is Amanda Odoi, asking that why don't they allow the process of Parliament to end? Because as they know, and has been the normal cause, when a bill comes to Parliament and the bill is done, it is sent to the president for an assent to that bill or otherwise. So the president can decide to assent to the bill or refer the bill to back to Parliament for a lot of things to be done. But in this case, when the bill, they wanted to transmit the bill to Parliament, the Attorney General was notified, and the Attorney General actually wrote a legal opinion on this, urging the president not to accept such a bill because it's going to be a huge and a significant charge on the consolidated fund. But the Attorney General says that by this process, if the argument of the Mr. Tadesori, the Speaker's lawyer, is that they should allow the process to go on, the president should take receipt of the bill, and then the president can take other actions, including sending the bill back to Parliament. In that case, then the jurisdiction of the court would be properly invoked under Article 2(1), where any person can come to court and then seek remedies that the Constitution of the Republic of Ghana has been infringed upon. But their failure to allow the process to end, and by so doing, by they truncating the process because they are not going to allow the bill to be transmitted to the president, that is his beef. And that is why he's asking the Supreme Court not to grant the wishes of the applicant by granting them that interlocutory injunction, injuncting Parliament from transmitting the bill from Parliament to the president. And so it's raged on for some time. The judges rose for quite a while. We even thought that they were going to render their decision, only for them to come back to say that, well, they have adjourned the case involving Amanda Odoi to the 17th of July 2024. And so we are hoping and expecting that a decision by the Apex Court would be rendered at that particular point in time. You know, there were two cases, and so that was the first by Amanda Odoi. The second case that was called involved Richard Delaskai, and he is the applicant in this case, and his lawyer also canvassed along similar lines, but there were some reliefs that were a bit different, and that is why I guess that is the reason why the Supreme Court did not consolidate the two cases and decided that they will give their ruling and their decision differently from Amanda Odoi to Richard Delaskai. He indicated that the charge on the consolidated fund is a huge one, and should the court grant the wishes or to injunct the process, it would be good. Otherwise, it will open the floodgate for other private members to be going to Parliament with such bills that will consequentially, impose some financial hardships and burden on the consolidated fund. The Attorney General, the learned Attorney General, rose up and said, well, he has nothing really significant to add except to reiterate his earlier position and his earlier point he's made in the Amanda Odoi's case, that even though that one has been done, he feels that Parliament cannot come back and then deal with the matters that are here. In fact, we spoke with the counsel for Richard Delaskai, and he says that they are not worried that the court did not consolidate the case, and that they are looking forward, they are hoping that their wishes will be granted on the 17th of July. In fact, their case was also adjourned to the 17th of July, where the Supreme Court says that it will render the decisions differently from there. So, as usual, the court was packed with a lot of people. In fact, it was filled to the rafters, journalists and other people, because it was really an interesting case that people really wanted to know what on earth was the injunction for. Why is it that they are not allowing the process of Parliament to truncate? Because normally people feel that in cases that have been decided, Parliament finishes its work, and after that, the bill is transmitted to the President for his assent, and then if it is passed into law and there are defects or there are fundamental breaches that goes to the root of the Constitution, then someone can actually invoke the jurisdiction of the court to bring the matter to the court for the court to determine that there have been instances where the court had done that. And so they are wondering why this case is different, that the relationship that exists between Parliament and the executive had been truncated midway when the process had not actually ended. In fact, the argument by the lawyer for the Speaker of Parliament, and for that matter, Parliamentary, indicated that once the work of Parliament begins when the bill is introduced into Parliament, and then there is a consideration by Parliament. It goes through the first reading, the second reading, until the bill is passed by Parliament. After a bill is passed by Parliament, it is sent to the President, and then when comments or suggestions are made about the bill, if the President is not assenting to the bill, then it will come back to Parliament, and Parliament in itself, on its own motion, will cure the defect here. But in this case, Parliament's work, he believes, has been truncated, and for the Supreme Court to come in and intervene will be like intervening in two friends that are having some friendly quarrels, because this has been the normal course of business. This is a presumption of regularity where Parliament does its work, and then the bill is transmitted to the President for the President to assent to the bill. And so we've been speaking with lawyers for both of them, Lawyer Ernest Akon, and he feels that on 17 July, his position will be vindicated, and the court will so grant his wishes by injuncting Parliament from transmitting the bill. Now, it comes to the question that after Parliament has been injuncted from transmitting the bill, what next? But the Attorney General has a position on this, that the very foundation of this bill was not properly entertained, because he feels that there was a lot of work that needed to be done to satisfy the condition precedent. And the condition precedent is one, under Article 108, that if a bill that is introduced in Parliament that is not emanating from the office of the President or from the executive seeks to impose some burden on the consolidated fund, that bill ought not to be entertained in the first place. So fundamentally, he feels that the bill should not have been entertained in the first place. Parliament should not have entertained this bill through the reading and all the discussion and all the debate that were garnered across the country and all of that. It was so unuseful, because the right thing that Parliament ought to have done, Parliament never did it by asking the relevant questions whether this bill was emanating from the office of the President or from the executive, or whether the private member's bill that was being introduced would be a charge on the consolidated fund. So we'll be back at the Supreme Court on the 17th of July 2024. You know, the last time that we were in court, the parties, that is the applicant, Amanda Odoi, the researcher from the University of Cape Coast, and lawyer and journalist Richard Delaskide, sought leave of the court to amend certain processes that they had filed so that they come back to court. And so the court slated today for the case to be heard. In fact, it's been raining the whole day, and so the court proceedings did not even start right on time. It was scheduled to have started around 9, but there were other cases that were called before this very case, because this very case was the one that many were looking forward to. But the Supreme Court hasn't risen yet. There are more cases that are before them that they are hearing. In fact, it was really an interesting debate over the Article 108, whether it was proper for Parliament to have entertained the bill right from the outset to the stake that it has reached, and then there is a disagreement as to whether the President should accept the bill, or should Parliament should really transmit the bill to the Presidency for the assent. But others are also saying that Parliament in itself is an institution. The institution of Parliament is independent from the judiciary, from the executive, and so actions that are done by Parliament, they have the power to rework any defects that occur, provided that the bill has not been passed into law. The other proponents are saying that why even go ahead when there are fundamental breaches to the bill that you are canvassing in Parliament? And so these are the positions. The first position is that the bill should not have been entertained by Parliament. Why? Because it's an affront, or it contravenes Article 108 of the 1992 Constitution, in that it imposes a charge on the financial resources of the country. The other school of thought is indicating that, well, once Parliament has done its work, why don't you allow the process to continue, the process to end before we truncate the process? Because once the President, if the bill gets to the President decides that, well, I have the bill, let the people send the bill to the President says that I have the bill, and then let me decide whether to assent to the bill or not. Once the President decides to assent to the bill, then it becomes law. Once it becomes law and there are breaches, then an individual, someone under Article 2(1) of the Constitution, will go to the courts, for the Supreme Court, to quash the decision of Parliament, or to just set down some of the provisions that are in the law that have been done. And so that's is the situation for now. At the Supreme Court, the lawyers are now leaving the precinct of the courts, and they are hoping to return on July 17 for the ruling of the court. Indeed, whether when we come back, the court will really have a ruling, or there will be other processes that will be filed as an interlocutory process that will not make the courts come with their ruling. We heard there from lawyer Tadesori that he has some processes to file before that. And so we are looking forward that by the 17th, when we are back in court, something really would be done, or the court will really trigger this process. But the fact is that when a bill is sent to Parliament, prima facie, it should be from the executive. That is the argument canvassed by the Attorney General and the applicants. Once it is not coming from the executive and it's a charge on the consolidated fund, then there is a problem. And that is why we are in court currently. The basis of their argument is that the bill will impose substantial hardship, and then it will affect you and I, the taxpayers' money that is there, because they have done the financial analysis and all of that, and then they have come to the conclusion that once this is done, it will be a burden on our prisons, because other people will fall foul of the law. They have to be jailed. Other people too. There will be other breaches and fundamental human rights that will be tied. And that is where the argument is. So we are still at the precinct of the Supreme Court.